What is a statement of defense? A statement of defense, for purposes of a civil action before the court, is a formal legal response of the defendant to the factual allegations and legal claims of the plaintiff that were set forth in the plaintiff's statement of claim in Canada and other Commonwealth countries. In the United States, the defendant files an answer to the plaintiff's summons and complaint. The statement of defense sets out the defendant's position in the litigation, admitting or denying allegations made by the plaintiff and presenting the defendant's own version of the facts, although generally not setting out the evidence by which those facts are to be proved. Each court's specific rules and procedures includes the required content of the statement of defense and even its specific format. In general, the statement of defense sets out the case caption at the outset and then proceeds into a series of numbered paragraphs where the defendant must respond to each allegation set out in the statement of claim by either 1. Admitting the allegation, or 2. Denying the allegation, or 3. Contending no knowledge as to the allegation. The law thereafter treats each allegation that was set out in the statement of claim but not responded to as having been admitted to, such that it is essential that the defendant respond to each and every allegation contained in the statement of claim. As such, the admissions, denials, and assertions of no knowledge tend to be responded to with very broad and inclusive responses, with the defendant listing out all those numbered paragraphs in the statement of claim or clauses therein that it admits, denies, or contend no knowledge of. Furthermore, simply denying the defendant's version of the facts is generally not enough, where the defendant intends to prove a different version of the facts, such that the defendant must plead the defendant's own version of the facts in the statement of defense. The defendant also needs to be pleading any matter on which the defendant intends to rely on to defeat the claims. The defendant also needs to be pleading any matter on which the defendant intends to rely to defeat the claims of the plaintiff, and which, if not specifically pleaded, might take the plaintiff by surprise or raise an issue that has not been raised in the plaintiff's statement of claim. The statement of defense may and sometimes must contain affirmative defenses. For example, failure of condition precedent, failure to state a cause of action, laches, statute of frauds. In this regard, the defendant needs to be careful not to waive any defenses. Certain defenses, based on court jurisdiction, such as contesting performance or occurrence of a condition precedent, need to specify in their statement of defense the condition and its non-performance or non-occurrence. The statement of defense may be combined with other pleadings, such as 1. A counterclaim that is brought by the defendant against the plaintiff and seeking relief from the plaintiff, much in the same way as a plaintiff's statement of claim. 2. A cross-claim that is brought by the defendant against other defendants, and or 3. A third-party claim that is brought by the defendant against parties that were not named in the statement of claim. A copy of the statement of claim must be served on the plaintiff's lawyer or if self-represented on the plaintiff personally and upon all other parties. The exact specifics of service and filing are set out by the court in its rules and procedures. Unless an extension is provided by the plaintiff or the plaintiff's lawyer, the defendant must file and serve their statement of defense or a notice of intent to defend, demand for notice, followed thereafter by the statement of defense, within the stipulated time frame set out in the statement of claim. The defendant's failure to file and serve the statement of defense or notice of intent to defend, demand for notice, within the stipulated time frame allows the plaintiff to ask the court to note the defendant in default and then obtain a default judgment against the defendant. If a default judgment is awarded against the defendant will be necessitated to bring a motion before the court to petition for its removal. And as with all pleadings and procedures, particular attention must be placed to the court before which the litigation has been brought and that court's specific rules and procedures. Thank you.